Good morning. May it please the court. I'm Debbie Williams, pro se appellant plaintiff.
Well,
This is my first time appearance.
Well, Ms. Williams, we're very pleased to have you with us this morning.
Thank you.
I understand you're going to represent yourself, and
Yes.
you are absolutely entitled to do that.
Okay.
As you have had the opportunity to observe attorneys presenting their arguments in the first two cases, you have 15 minutes to present your argument, and the other side will have 15 minutes as well. Right. You do have the right to reserve up to 5 of those 15 minutes if you want to respond to what they have to say.
Okay.
Do you wish to reserve some of your time?
I can reserve 3 minutes. It's going to also depend on, I should be able to finish.
We'll reserve 3 minutes for
Yes.
you, so we'll set the clock at 12 minutes, and when the light comes on yellow, it means you've got a minute to wrap up, and the red means you're up. All right.
All right,
You have our attention, Ms. Williams.
All right, thank you. The trial court looked at 2 components of the summary judgment for Holt's and Keys: intentionality or intentional and outrageousness, extreme behavior of conduct. In Record 16 of the CD-ROM for 2024-0621-12.26.07.921, at the time 30153 through 30158, the trial judge stated, "I'll give it to you as far as intentional." So I'm going to close that. At 30023 through 30053, the trial court judge stated, "They are not challenging your claim that you were injured, but challenging the outrageousness of your claim. It has to be outrageous. Usually torts are reserved for physical harm. If someone was to come up and punch you, runs their car into you negligently or intentionally doing something, they create this tort for those situations." The error that I am presenting is that intentionally leaving, intentionally speaking fraudulently to an elderly female ill-clad without a coat or a jacket in the low 20 degrees weather is an objective factor, not a mere insult, a mere rudeness, a mere unkindness, and so forth, but it is an objective, outrageous action behavior that should not be tolerated by any decent, civilized society. I went following the guidelines of MTA at its terminal to catch the 3A bus on November the 15th, 2022. It was unseasonably cold. The temperature itself was in the 20s and the wind chill was in the low 20s. I went to Bay 5. The operator during the service for MTA on MTA bus stayed at its non-designated bay for over 4 minutes, while the designated bay was vacant and didn't drive up. And it's from experience, he's not to allow someone to board his bus at a non-designated bay unless a supervisor comes out and tell the people, or he himself comes out and tell the people, whatever the situation is, to go and board at a non-designated bay. But when he got ready to leave Bay 3, Bay 5 is right above that. When he got ready to leave Bay 3, instead of traveling down the lane directly to Bay 5, he altered the trajectory of the bus into the inner lane, the exiting lane of the terminal. So I moved closer to the edge of the safety. It's elevated. The safety boarding area, I got his attention. He swirled the bus into the Bay 5 area. I had to step down onto the pavement from that elevation and walk towards the bus. And he said, and it was sternly said, but I just ignored that. He said, "Get on now." I said, "Lower the steps." And I looked down, waiting for the steps to be lowered to board the bus. I'm seeing the door of the bus close and the driver exiting out of the terminal. And when he did that, the judge looked at, okay, that was the end when he shut the door. But when he shut that door, he closed me out into the cold, ill-clad, in low 20-degree weather. And all I'm trying to do is that's an objective factor, and that's what I am challenging there. He viewed it as non-subjective. But just by looking at his behavior stopped when he shut the door. But when he shut that door, he closed me out from boarding the bus into that cold temperature.
Now, Ms. Williams, what did the driver was Mr. Holt.
Yes.
But what did the Ms. Keys, what did she do to offend you so badly?
Yes. Once the bus left, I went to seek a supervisor. The customer care center station you're still outside. And so when I waited for her, she left she approached from the area of Bay 5, so I assumed she was coming from the break room, which is about a couple of feet from the Bay 5 boarding area. So I waited for her out there, and still in the cold. She came. When she came, she conversed with me. We're still outside, so I'm being still subjected to the inclement weather. She said, during the conversation, she said, you go ahead and you file a report, complaint, and I also will file one. I'll pull the tape and see what happens to see if he will allow other people to board. And also, the job requirement for the supervisor is to monitor bus service to assure adherence to schedules and safety regulations, supervises the performance of bus operators, and collects the information necessary to investigate customers' public complaints. So she's out there talking to me all of this time, out in the cold. I'm still feeling the effects of that. She did nothing. So all of this time, she's fraudulently conversing with me, subjected me to that cold temperature. Still, she could have just simply told the lady that summoned her by phone, I'm not going to do anything. So she had me out there listening to her. She's telling me what she's going to do. She did nothing. And I was subjected to all of that while I was still feeling the impact of that cold temperature on my body.
Well, what could she have done at that moment other than to make a record of your complaint? She couldn't bring the bus back. What could she do?
She could have said, okay, we can go into, she could have fulfilled her responsibilities, or she could have said, let us go into this waiting area here and I'll converse with you there. Or there have been instances where the supervisor, they have little vans or little buses stationed near there's a little area there, I guess, where they have the monitors that people can observe. They will take an individual to either go and meet up with that bus or take them to their destination. They do have that option.
All right, thank you.
They have like little vans and things. Okay, and then when I filed the complaint on the 15th, before they were asked the question before you submit, do you want WeGo or MTA to contact you? And I'll press the yes button. I would like to hear from them. Immediately on that day, an automatic reply from MTA was sent to me, stating that within 2 to 3 business days, I can expect to hear from a quality assurance investigator. Well, I waited. About 7 days went by. I still had not heard anything. So through another portal, I think it was either the Hub portal or I filed another complaint. Again, before you submit it, they asked the question, do you want MTA to contact you? And I said yes. Well, I didn't hear anything. And so I complained through the Hub, Nashville Hub government portal, that I'm not receiving any information from WeGo. And so what happened was that one of Mr. Scott Wallace responded that same day. He's not affiliated with MTA. He said, I'll get someone to contact you. Well, no one did. So I let him know, so many days went by, I let him know that. So he said, let me add 2 more people to this thread. And he said, or to this post, and so to contact you. And so on December the 20th, I finally got to hear from Georgina Beatty. And at the very top of her email said, customer comment has closed this complaint. And then for the next complaint, she said the same thing. We have closed this. Okay, when through interrogatories, MTA produced the customer report, which was a different format. On the reply to customer section, it was written, the customer did not give MTA permission to make contact. And I'm going like, yes, I did. And I have even from MTA itself saying that I will hear from a quality assurance investigator. And also, in my second complaint, which was filed on November the 23rd, I specifically said on there, I have not heard from a quality assurance investigator. That was November the 23rd. That was that complaint. And then I'm getting messages that the complaints are closed. And then on here, I can see why you got them closed now. If you go, whoever put that on there, I don't know where they got it from. But then I was asking the court, I need to have those original complaints that I filed, because the complaint that I filed and the complaint that MTA produced, that was a different format. So the complaints that I filed did go to MTA. So I'm asking for those. And then the judge says, well, that request to compel discovery, simply because MTA says, we don't have it. And so he said, denied. So I'm being denied, and you're telling me they're writing on there, I didn't give permission, which contradicts what MTA himself said, someone will contact you. And so that was the first discovery request that I am challenging I'm asking for to be reviewed. Because what was written on the form and what was written on, if I didn't give permission, then that negates any type of, negates my claim of negligence against WEGO, because negligence, because if I didn't give permission, WEGO is not obligated to, MTA is not obligated to hear from me. And then on the, it says 43. Yeah, but I think enough in my brief, in my reply brief, will be able to address all of the others, but I continue, I have a few more seconds. In the findings, when I requested what were the findings, that was my interrogatory. In their response, information was omitted. They had copies, I think it's 000, the 13th and the 16th in record. They submitted those forms, and in those forms there, they left off the comments about what Eugenio said, this will be forwarded to the operations team to take the appropriate behavior for the bus driver Holt's unprofessional behavior. So when she glanced at it that particular day, she saw that was not right with what he had done. And so MTA had those records, but in their response, they specifically omitted that comment. And I said, wait, insert that comment into my request. It is a finding, it is an assessment. Why did you leave it off? Then they say, well, this is outside of the scope of that question. Well, you're the one who omitted it, insert it in there, and then give a reply. But the judge says, no, it's outside, but I submit to the court for review. It is inside of there, it is a finding, and you had in your possessions you had in your possessions those comments.
All right, we understand. Thank you, Ms. Williams.
All right.
We'll hear from you again on rebuttal.
All right, thank you.
Good morning.
Good morning. May it please the court, I am Janet Hayes from the Knoxville Bar. I am here today on behalf of the Appalese Metro Transit Authority, Rodney Holt, and Tyquinta Keys. Before launching into my legal argument, I would like to echo something that the trial court said when ruling from the bench. The judge made it a point to say that he believes Ms. Williams is sincere in expressing her subjective feelings. He described her as personally very offended. He also acknowledged that she had been personally insulted. And let me say at the outset, MTA does not dispute and in fact wants to acknowledge that Ms. Williams had a bad experience. My arguments today are not intended to further her bad experience or to minimize her subjective feelings. However, the legal standard before this court is objective or reasonableness, and the law simply does not provide relief for being offended or insulted. Instead, the torts that Ms. Williams has alleged are reserved for serious and severe or atrocious conduct that cannot be tolerated in a civil society. Our Tennessee Supreme Court has repeatedly acknowledged that life, in fact, is riddled with inconveniences and even distresses that are not legally actionable. Quoting from Rogers v. Louisville Land Company, our Supreme Court said, "Complete emotional tranquility is seldom obtainable in this world. Some degree of transient and trivial emotional distress is part of the price of living among people. The law interferes only when the distress inflicted is so severe that no reasonable man could be expected to endure it." Here, Ms. Williams has failed to show the requisite degree of severe emotional distress required to be actionable under the law. Ms. Williams has appealed 3 separate orders from the trial court. I would like to address first and primarily the order granting summary judgment to the individual defendants, Mr. Holt and Ms. Keys, as I think that arguments on that order really inform the ruling on the other orders as well. To prove intentional infliction of emotional distress, as this court is well aware, it is the plaintiff's burden to prove 3 specific elements. The plaintiff has to prove that the conduct was intentional, which has been defined to include reckless, that the conduct was so extreme and outrageous that it's not tolerated in a civil society, and that the conduct resulted in a severe mental injury. Here, the trial court granted summary judgment based on the second element, the severe or extreme emotional distress, though I would argue that Ms. Williams failed to present adequate proof on all 3 elements. With regard to the severe or extreme emotional distress, as this court has said many times, to prove that tort is a very high threshold. As I looked through the case law on intentional infliction of emotional distress, I found that we are more apt to describe what it is not than actually what it is. And what it is not, according to Tennessee jurisprudence, it is not mere insults, it is not indignities, it is not annoyances, it is not petty oppressions. It's not sufficient that there was an intent to act in a tortious or even criminal way. It's not enough that the conduct is characterized by malice, and it's not enough that the conduct is such that it might even warrant punitive damages with a different tort. So what is it? It's rare. It's cases where the conduct is so extreme in degree to go beyond all bounds of decency and be regarded as atrocious and utterly intolerable in a civilized community. And as we're all aware, it's the conduct that upon hearing it or reading about it, it causes one to gasp and exclaim, outrageous. So where has that conduct been? Well, according to the facts where the courts have found that conduct, in one case, it was where a mail carrier suffered PTSD and major depression after a man asked her for assistance with his wife and then shot his wife and then turned the gun on himself. That's extreme and outrageous conduct. Another case is where a plaintiff experienced death threats and the defendant, while threatening, fired gunshots near the plaintiff's home and exclaimed, "There's fixing to be a killing in the holler." These are cases where someone is in imminent fear or the conduct is just absolutely outrageous. I would ask the court to contrast those facts to this case, the facts that Ms. Williams has alleged. And while there are some disputes about immaterial fact, we would ask that the court take her allegations for purposes of summary judgment as true. Assuming the facts she alleged, she alleges that a bus driver could have pulled into her bay where she was waiting 4 minutes sooner. She alleges that he did not pull the bus in at the proper trajectory, causing her to have to step down a step onto the concrete as opposed to boarding from a step higher. She alleges that he did not lower the bus and that he opened the door and said, "Come on now," and that when she did not board, he closed the door and drove away. That set of facts sounds like an allegation of poor customer service. It is not an allegation of extreme or outrageous conduct. And with regard to Ms. Keys, there's even less. The only allegation is that when Ms. Williams approached Ms. Keys instructed her to file a complaint, and though Ms. Keys does not even remember the interaction, assuming Ms. Williams' version of events, Ms. Keys said, "You file a complaint and I will file one as well," but there is no proof in the record that Ms. Keys actually filed a complaint, though there is proof that the plaintiff filed the complaint, that it was investigated by a customer service representative, and that it was appropriately dealt with. This conduct was not extreme and outrageous, and the trial court was correct that no reasonable jurors could find it as such. But even if you got past extreme and outrageous, I still submit the other two elements of the tort are not present. The plaintiff, Ms. Williams, has failed to demonstrate that any conduct was intentional. In the Roman Diocese case, it was determined that intentional conduct in the context of this tort means a conscious objective of causing the result, here causing emotional distress. There's no proof in the record that either Mr. Holt or Ms. Keys acted with an intent to cause emotional distress. Likewise, there's no proof in the record of a severe emotional injury. The severe emotional injury, I think, sometimes goes hand in hand with the first element, the extreme and outrageous conduct. But again, here, in the absence of a physical injury, the court has said you must show a very extreme emotional injury. And while, again, I don't want to be offensive or discount Ms. Williams' subjective experience, by reasonable standards, it simply does not rise to the level of an extreme injury that's contemplated by this tort. Now, Ms. Williams also challenges this order under Rule 56.04. She makes another lakeside challenge. This time, the challenge is not that the trial court failed to exercise independent judgment, but she says that the order does not adequately explain the ruling. I would simply ask the court to look at the order in the record. The trial court identified the tort at issue, explained that one element of the tort requires proof of extreme and outrageous conduct. The trial judge said in the order, and I quote, "Reasonable minds could not differ that the conduct of defendant Rodney Holt and Tyquinta Keys was not extreme and outrageous, a necessary element of the claim." This was in the written order after the trial judge offered a full and detailed ruling from the bench, even explaining the history of this tort and explaining the difference in subjective and objective standards. Frankly, there's little else the court could have said to explain the ruling, and the lakeside challenge fails. Ms. Williams has also appealed the order granting summary judgment to MTA. In her complaint, she seeks to hold MTA vicariously responsible for the torts, the alleged torts of Mr. Holt and Ms. Keys. And MTA asserted governmental immunity. Before getting to the issue of governmental immunity, I think it is pertinent that we step back and look at the idea of vicarious liability. Quite frankly, no one can be vicariously liable for a tort when there is no tort. The tort that she alleges in this context is that Mr. Holt and Ms. Keys engaged in negligent infliction of emotional distress, but as this court is aware, Camper versus Minor, negligent infliction of emotional distress is very similar to the cousin tort, intentional infliction of emotional distress. It too requires a serious or severe injury. So without reiterating all that, for the same reasons, the tort of intentional infliction of emotional distress fails. The tort of negligent infliction of emotional distress also fails. So I would suggest that there's no need to even get to the issue of governmental immunity. But even assuming that the tort did exist, there's no question but that governmental immunity is in place. Ms. Williams seeks to employ an exception under the statute. She wants to say that Mr. Holt and Ms. Keys were employees of MTA, and therefore their negligence can be attributed to MTA. However, in this context, the statute gives us very specific guidance. The statute presumes that an individual is not an employee, but establishes 5 criteria and says in order to be an employee of a governmental entity, there must be proof of all 5 of the criteria. In this case, Ms. Williams, while she offered a lot of proof, did not offer proof of those 5 criteria. And so she failed to establish that essential element, and perhaps more importantly, MTA offered affirmative proof. They offered an affidavit from Vince Malone, the Chief of Staff at Davidson Transit Authority, to show that 3 of the 5 criteria simply didn't exist. The criteria, the governmental entity must select and engage the individuals at question. Here, MTO did not interview. In fact, Davidson Transit Authority interviewed both Mr. Holt and Ms. Keys and made the decision to hire them. The second criteria demands that the individual at issue receive all of their compensation directly from the payroll department of the governmental entity. Here, neither Mr. Holt nor Ms. Keys received compensation from the payroll department of MTA. Instead, they received it from Davidson Transit Authority. And another criteria requires that the person act under the control and the direction of the governmental agency. Here, the individuals were managed by employees of DTO and received direction, if needed, from employees of DTO. So the plaintiff failed to.
If you don't mind, clarify that corporate structure, because the record refers to the Metropolitan Transit Authority, WeGo Transit Authority, Davidson Transit Organization, and I think there's a 4th, but what?
Metro Transit Authority is the entity that has been sued. Davidson Transit Authority is a separate entity. Davidson Transit Authority hires employees, manages the employees that work at MTA, at the Metro Transit Authority. If I understand the arguments Ms. Williams is trying to make.
What is
it manages the people that work at MTA, you just said.
At the location.
At the location. Okay.
I'm sorry, let me clarify. The employees are employees of Davidson Transit Authority, but as is the case in many instances, they're employees of Davidson Transit Authority. They may work on the premises of MTA, but they're employed by Davidson Transit.
And what is the Davidson Transit Organization?
It is an entity that's created to hire and manage employees, and they're the employees.
Well, I thought you said that was the Nashville Transit Authority.
No, Your Honor.
Okay.
No, it's Davidson Transit Authority is the employee that.
Metropolitan Transit Authority, then the Davidson
Transit Authority. Correct.
Metro's contracts with them.
Yes.
Is there a Davidson Transit Organization?
I'm sorry, I'm speaking incorrect. DTO, Davidson Transit Organization, I apologize for using the word authority. Davidson Transit Organization is the entity that hires the employees, that manages the employees. Metro Transit Authority is the facility, that's the governmental entity that has been named in this case.
Okay, and who owns and runs the bus line?
I don't know that I can answer that definitively or that it's in the record, but I would assume it's a governmental entity. The Metro Transit Authority, I think, is the entity that is running the bus line, but forgive me if I don't know that that is necessarily in the record. But
they contract through the Davidson Transit Organization.
Davidson Transit Organization.
To hire the employees who drive the buses.
Correct.
Okay.
And the issue, the alter ego issue between those two entities, I would direct the court. It has never been raised in this context, and I would argue it because in this context the statute actually governs and tells us when someone is an employee. But in other contexts, it has been raised in federal court, and the court has said, Federal District Court, Eastern District of Tennessee, says, and I quote, "These are separate legal entities, and only DTO is involved with day-to-day operations, such as disciplining, hiring, and firing employees." So I think that's informative and pertinent.
All right, thank you.
In conclusion, I would simply say that the plaintiff has alleged allegations of poor customer service, not legally actionable complaints, and we ask that the trial court, all three orders be affirmed.
All right, thank you, Ms. Hayes. Ms. Williams, you have the right to a rebuttal. You've reserved 3 minutes for that.
Oh, okay, thank you. That is why it is important to have that video footage. It shows the trajectory of that bus. There won't be any question. It also shows my communicating directly with Holt, that when I said lower that bus, at that statement, he immediately shut the door and drove off because he wasn't going to do anything else. His intention was never to leave Bay 3 in the first place. And it's also important because but the trial judge says that my petition to compel MTA to submit the footage was viewed as insufficient, or it wasn't the right word that they said. But MTA has a retention policy, and I outlined that in my brief. And also, the day that on the 22nd, Bryant Williams, performance personnel, had emailed me that morning about 8 o'clock. About 6 hours later, I said, MTA, and he had the footage at that point. I said, MTA will be used, it will be a defendant in a civil law tort lawsuit. That was 6 hours later. MTA says we're not in possession of the footage. When I asked through interrogatory, when on the 25th, I had emailed the CEO, and I said, do you have a separate legal department? On the 27th, Vince Malone sent an email. So he said, I am the chief administrator for MTA. He said, any legal concerns, he said, documentation, he said, send them to me with the title, my title, which is Chief Administrator for MTA, with the address which was at MTA's administrative office on Myatt. So DTO and MTA have the same address. When in 1992, MTA, and it's written in the brief, MTA established DTO, Davidson Transit Organization. There was no Davidson Transit Organization. MTA created it. MTA tried to hire all its employees. It had just gotten this CEO, and the Metro government gave all of that authority over there. You are in charge of this public transit organization. MTA said, okay, I need to hire my own people. But I can't, because there are laws and statutes, federal and state, that are contradictory. So what MTA says, okay, that's fine. What we're going to do, we're going to call this organization that we're going to create a 501c3 organization, nonprofit. And therefore, we're going to work through that organization and hire our own people. But we're working under this shell of this DTO. Mr. Anderson, Tim Anderson, in his deposition of 2008, is in the brief. 2008, he explained it well. He said, there is no written contract between DTO and MTA. Why? Because that's MTA baby there. He's going to create it. So whatever MTA needed to satisfy whatever the laws for a nonprofit, MTA took care of it, including setting up that financial account. And then what happened was this. Mr. Sanders said, look, everybody in this organization, everybody in DTO works or perform in the capacity role for MTA. So if you were to take everybody and say, Okay, everybody who does not have a road capacity for MTA, you all leave this building. There will be nobody for DTO. They all perform in a road capacity. So the bus driver is simply identified by DTO
All right,
as an
Ms.
employee.
Ms.
Oh,
Williams,
I'm
you've
sorry.
made your point, and your time is way up, so.
Oh,
I'm
okay,
sorry.
it still said 106.
You've made your point.
Okay, thank you.
Thank you very much. That concludes the docket.